the challenge to the Data Protection Authority, like the Information Commissioner's Office here in the UK, is that enforcement challenge. We published our annual report last week, and a lot of information is there on the website. And the theme was openness and privacy, making a reality of information rights. And the challenge to the ICO is to be effective, efficient, and relevant. And the new powers we've got with our civil monetary penalties to make those stick without having to prove under the Privacy and Electronic Communications regulations that substantial damage or substantial distress has been caused by a nuisance, phone calls, for example, and spam texts, is an example of giving us the tools to do the job. Because if you've got effective enforcement and people understand that there's effective enforcement, then that has a deterrent effect. People say to me, well, you're being overly pragmatic when you don't propose to enforce for every minor breach you see. But you see, I think it's much more effective. This is following the de Gaulle principle of deterrence. If there's an element of uncertainty there, I might be caught, I need to take this into account. That's what is actually more effective than the sort of box-ticking process approach, which seems to be the consequence of some of the iterations of the regulations. I absolutely endorse what David's just said about effective enforcement being what makes this run. So give us the tools, and the evidence is that the ICO can do a very effective job. We've got, again, recently, the power of non-consensual audit for data protection compliance in the health service sector, which in the UK is a hugely important sector. And we're going to use that because the health sector is naturally dealing with sensitive personal information, some of the most sensitive personal information. But frankly, that's not enough. We've got the integration of health and social care. Social care is delivered by local authorities. Local authorities have a pretty dismal record of compliance with the Data Protection Act. If you have a power of non-consensual audit for the health sector, why not for the local government sector? And it's a point I've made to the new Secretary of State, Greg Clark. Similarly, I'm not going to go away when it comes to having a serious penalty associated with a criminal offence under the Data Protection Act, Section 55, the unauthorised obtaining or disclosure of personal information without the consent of the data controller. It's not that I want to swell the prisons with people who've broken the Data Protection Act, and I know we've got a problem about too many people in prison and prison not doing them very much good. But I want people to understand this is a serious offence, I could go to jail, rather than the courts only have the power to impose a fine. And of course, the fine always has to take into account people's ability to pay. So it's a business cost. It's a risk worth running. So we want the custodial penalty introduced. As we learned this morning with the revelations in the Daily Mail about Boiler House what should we say? High-pressure canvassing for charities is a kind way to put it, but basically the misuse of lists to contact often quite vulnerable people to contribute to charities or to up their giving. It's really quite interesting what the Daily Mail did in terms of getting into that boiler room. They can do as journalists, but I can't do as a regulator. I would have to get appropriate approvals under the Regulation of Investigatory Powers Act to do what Daily Mail journalists can just do. I'm not complaining about it. I just say that sometimes the regulator needs to have a bit more power in order to get to the bottom of things. Looking ahead to our other priorities, obviously we've got our work cut out responding to changes in jurisprudence, both at the European level and also in the UK, the right to be forgotten following the Costea judgment. We're working through the complaints that are coming to us about the refusal of search engines to honour that judgment. So far, it's going pretty well. There's a reasonable dialogue. I predicted a tsunami It isn't quite a tsunami. It's about 200 cases we're dealing with, but they are pretty challenging. But nevertheless, we're making progress, and the evidence is that the search engines do listen to us when we go back to them and say, are you sure you've got that right? Similarly, the Rhinus judgment and domestic CCTV. And then an interesting development is that the UK courts themselves have started to apply the Charter of Fundamental Rights in quite an interesting way. So that decisions in the UK domestic courts, I'm thinking here of the Vidal Hall case, are applying the Charter of Fundamental Rights in a way that I think some UK politicians find quite uncomfortable, but there we are. Obviously, the security situation, and one's thinking particularly today, it's the 10th anniversary of 7/7, the bombings on the London tube system and the buses. There are all sorts of issues around security and surveillance which have a data protection dimension. 2 points here. I voted in favour, or giving my view, that the European regulation was going to be sorted out by the end of 2015, because I think the security dimension, post-Snowden, post the Charlie Hebdo and so on, mean there's much greater sense of urgency to sort the whole data protection piece out. And I think that there's a reasonable prospect that the necessary compromises will be made. The role of the data protection authorities is not to be campaigners like the civil society organisations who are well placed to do that. We're simply there to offer a view as experienced regulators saying what works, what doesn't work. And if we're not convinced by proposals, we're not prepared to say we don't think that they'll work. But we leave the campaigning to others. Can I flag to you, I mentioned co-regulation this morning, our Privacy Seal project, which is well on track. We've sorted out the competition issues. We're now stuck on the logo. You've got to design a privacy seal that means something to consumers and communicate something about the responsibility of a responsible attitude of data controllers, but which doesn't say things about the company that people don't actually want to sign up to. And also, I'm not prepared to subcontract the ICO logo as a sort of good housekeeping seal of approval, because I need to be in a position to intervene if people don't live up to their promises.